It is an event where all the legal administration officers of the department converge to engage, discuss, deal with challenges, and engage on best practices to ensure that we take the legal services that we provide to the department forward. Moreover, take into account that we are a support service to the core business, so in so doing, providing core support to the core business, we make to ensure that we have policies and procedures that ensures that we are able to take legal services forward.
Here is a grand opportunity for each one of us in the room to make our contributions to ensure that legal services undergo a paradigm shift in their outlook and approach. The language of exceptional litigation by oversight bodies is worrisome for us as the ministry, to say the least. By its nature, litigation costs money and should be the last resort and only invoked when all else has failed. Shouldn't be easy for us to just take anything to court or to defend any matter just because we have money at our disposal. Going to court should be a matter of last resort when all else has failed.
I was requested just to talk to objectives of this seminar, so I'm not giving an address, and I will do that by means of throwing questions that the seminar needs to answer, or questions that would guide the discussions. The first question is, how effective and how efficient are we in rendering the legal services support to the department? The second one is, are we maintaining the required standard of legal compliance and transparency in the work that we do as legal services? The third one is, how far do we go in ensuring that the department is protected against unscrupulous legal practitioners? How do we, and that is the fifth one, how do we avoid frivolous litigations aimed at making a quick cash out of government? The sixth one is, are we doing enough really in upholding the dignity and rights of those that we engage with on legal matters? The seventh one is the quality of legal services we are offering to the department. Is it at the required level? And the next one is, having assessed the implementation of our standard operating procedures, and I saw on the program there is an item that is going to talk to that. Are we following and implementing the standard operating procedures to the letter? The next one is, have we looked at or have we asked ourselves, why are we having so many default judgments? Do we have a central depository or a platform where all the new cases are filed? And this is basically administration. Do we take court orders serious? And if we are, why do we continue to experience this backlog that we are sitting with?
And we're here requested to talk about the challenges that are faced in the management of the entire state litigation. In my presentation, I focused on the 5-year state litigation strategy that has been developed by the Office of the Solicitor General, which has to be read together with the 6 policies that have been developed in line with the State Attorney Amendment Act, which came into effect in 2014. This policies is management of state litigation, initiating, defending and opposing of matters, briefing and outsourcing of state legal work, state legal representation, contingent liability, and mediation. So these policies, they're going to be assisting the state attorneys together with the client departments in dealing with the challenges that are being faced when coordinating and managing the entire state litigation. Okay, the policies are in fact in this stage implementable. The policies were approved in Cabinet in November 2022 and tabled in Parliament in March 2023 for noting. So at this stage we are talking about implementing the policies.